side in the courtroom. You've seen the rest, now hire the best. Contact Lee, Cosell, and Feigley today. And now, to address the legal concerns of the community, Praise AM 1310, 95.1 FM, presents Legally Speaking. Here are today's hosts.
Good morning, everyone. This is Nathaniel Lee. Thank you once again for listening to our show. Today, we have our usual superstar, Vanita Banks, and sometime Attorney Milton. But today we have the ultimate superstar judicial official, Chief Justice Randall Shepard. It'll take me probably the entire show to go through his whole credentials, but I'm going to give a quick summary of what's the important highlights. Justice Shepard, he's a seventh-generation Hoosier. He attended, among other things, the Yale Law School. He served as executive assistant to the mayor of Evansville. He also was the undersecretary for the U.S. Department of Transportation. He was a judge in the Vanderbilt Superior Court for several years. He became the president of the National Conference of Chief Justices, and he also served on the Judicial Conference Advisory Committee on Civil Rules, which the U.S. Supreme Court uses to form changes to the federal rules of civil procedure, which is very important in the federal court. And also, he was voted by retention to stay on the court. And he also headed up the Indiana Commission of Local Government Reform, which looked at ways in which to more economically run our state and local government. But the unusual thing about the Chief Justice is that he's the only Supreme Court judge who was honored by both the American Bar Association and the National Bar Association for his effort in supporting diversity. Indiana has a state program called ICLEO that provides scholarship for economically disadvantaged and minority students to attend law school in Indiana. In addition, the Judge Shepard has authored more than 900 majority opinions, 900. And since his retirement, he currently served as a senior judge on the Indiana Court of Appeal. Justice Shepard, welcome to our show today. It's an honor to have you, sir.
Great pleasure to be here. I look forward to our time together.
Okay, well, let's start out with a little background. What interested you and sparked your interest in the law career? How did you, were you always set in becoming a judge? How did you end up in this field?
Well, I hadn't planned on it, although I had always been interested in three general fields. One was law, one was business, and the other was journalism. And it was my mother who told me she thought law was the best choice among those. And I still have, she thought it prepared you for a lot of different options. And we would know that, wouldn't we? If we think about it, there are plenty of places in society where somebody's not practicing law in the sense of writing briefs and appearing in court, but they've gotten the law training and they help nonprofits or for-profit organizations run the business. And she thought that prepared you for a lot of different things. So it was my mother's view. And the other ones that I was interested in, I still take an interest. I'm interested in international affairs and international travel. And I still do journalism a little bit every now and then. I've over time written newspaper columns. Deciding to apply to be a judge, I tribute to my friend in Evansville, Ann Schmidt Walker, who sat down with me one day on a Friday night and said, "Are you going to apply for this new opening that's coming up on the Superior Court?" And I said, "No." And she said, "Well, you've made the wrong choice, and here's why." And she talked me into it. So I tussled on down and put in my application, and the rest is history, as the saying goes.
Well, you are seventh generation Hoosier. What has it been like to watch the state grow in both political, economic, and judicial sense during your tenure?
I have to say, I like what I see. There are things that we don't do well enough in Indiana. You keep reading lately. We've been reading a lot of stories about projects that create more jobs and cities that are interested in low and moderate income housing, and they've launched projects of one kind or another. I think one of the things I like about Indiana, and I feel a sense of pride, particularly right now when we're having a very contentious set of elections. I think if you were to turn on the TV station or walk down the sidewalk in other places, you wouldn't find the kind of camaraderie that mostly Indiana works from. We mostly trust each other. People, the campaign commercials, even the negative ones, are relatively modest. Not necessarily have a knife out in their hand. So I think Indiana's got a bunch of things to be proud for.
Well, can you describe your journey from law school to become the Chief Justice?
Yes. Well, one of the things I did right out of law school, you've mentioned it earlier, is there was a program at the U.S. Department of Transportation, and I've always been interested in transportation. And it was called the Honors Program for Young Lawyers. It still exists 40 years later, 50 years later. And the idea was to compete with judicial clerkships. So you'd bring people into the department who looked like they had a good career ahead, and you'd give them exposure to what the department was. And I got chosen for that. Now, I arrived in Washington about 6 weeks after the Watergate burglary. Quite a time to be in Washington, D.C. And one of the characteristics of that period inside the government was that folks up at the top or near top kept getting indicted, and they would disappear. And then there'd be a chance for advancement from the people. And the general counsel of the department, well, the number 2 person in the department got indicted. I think that's right, got indicted and had to go elsewhere. And the general counsel got asked to take the number 2 job, and he called me into his office one day and say, "How'd you like to go with me?" So I wasn't the undersecretary, but I was his assistant. And that was a fascinating sort of thing to be part of. One of the things I remember that just pops in my mind is we got, when I did this rotation through the department, I got to see all sorts of interesting things. They flew us in a department airplane up to New York one day. There were 7 of us, I think, to see this brand new thing that they were helping make happen called the World Trade Center. And we got in a wooden elevator and went up to the 102nd floor of the World Trade Center, where they hadn't put in the windows yet, for heaven's sakes, and got to look at New York. Although years later, I had a dinner up there, which sort of reminded me of that experience. So, but anyway, I wanted to come back to Indiana, so I had a lot of admiration for the then incumbent mayor of Evansville. So I worked for him from 5 years, and then my friend Ann talked me into applying to be a judge, and that led to the Supreme Court and the Chief Justice's office.
Well, you authored over 900 majority opinions. What are some of the most significant cases that came before you that you think impacted Hoosiers in the country and impact it had on Indiana law?
Well, I would say that there was just recently a program about some of this at the Inn of Court. The one they chose, and it's a pretty good one, is litigation that's based on the state constitution, not necessarily the federal constitution, because there is an Indiana Bill of Rights, just like there's a Bill of Rights that was adopted, attached the first 10 amendments to the U.S. Constitution. And there'd been interest in that over time, but it had dwindled a little during the period when Earl Warren was chief. State courts and state court rights sort of went out of fashion, and most decisions seemed to be based only on the federal constitution, which worked well enough. But it seemed to me the states had some responsibility to pay special attention, particularly where their constitution was different. Now, a state can't run a constitution that doesn't affirm the federal right, but if the state constitution affords more rights, then it can apply if the state courts will allow it, will listen to you. So pretty early on, I guess in the early 90s, I worked on an opinion called Price versus State of Indiana, which had to do with the Indiana Bill of Rights. And we looked at the federal rule on, I think this was a freedom of speech case. I have to think about that for a minute. Anyway, Miss Price lost under the federal constitution, and we declared that she'd won under the state constitution. And so that interest, and I wrote some articles and gave speeches about that. And I think in the long run, that has, I went to a program where that was one of the central features, was what's Indiana done on the state constitution. There were some pretty visible cases. Very visible case that made a difference was a case testing whether Evan Bayh could run for governor. The Republican candidate was John Mutz, then the lieutenant governor. And the question was, had the time that Evan spent living with Birch in DC and Virginia, did that actually count for residency in Indiana? We held that it did. But boy, the courtroom was filled on the day we heard that argument.
Yeah. Now, the one thing about that's critical, and during your administration, Indiana did something kind of unique. You ushered in technology that, in my mind, became one of the model for the country, because I do cases in other states. Tell us about that process. I think you started back in the 90s, and now we have one of the best court management systems anywhere on the planet.
Well, I'm glad to hear you say that. Because you've taken a recent look and maybe done some comparisons. I want to start off by saying that the terrific leader in accomplishing this was Justice Frank Sullivan, who now teaches over at the McKinney School of Law. And we started in a day when interested in this, when technology was a whole lot less sophisticated than it is in 2024. And but it seemed like the society and its operations could do better using newer technology. It was all in 1990, certainly when I was in the trial court, everything was done with typewriters and pen and paper. There were some one law firm in Evansville that had bought a new system that actually typed it on itself. That came with discs. It's a word that people wouldn't recognize, the name of the product. I have to ask some folks.
Lanier.
Well, yes, I think you're right. Yeah, good for you. And we couldn't afford that in the Superior Court, so we plunged ahead with our typewriters. But Justice Sullivan, in particular, could see this development coming, and at that moment, case technology was almost totally in the hands of county governments and county courts. So that even when we finally devised an electronic system that would allow you to keep track of cases, it literally took probably a whole decade for all the county governments to decide, because it was their decision. We weren't insistent on this on anybody. And Frank Sullivan, Paul Mathias, and a number of other, and a wonderful committee worked hard on this. Now, let me tell you and our listeners the difference. There was a political primary for a county prosecutor in Evansville, must be 2 years ago now. And The one candidate worked as a local public defender, and the other worked for the Attorney General in Evansville as a manager and case supervisor and so on. And the guy who'd been the public defender claimed that this woman shouldn't be chosen because she'd never tried any cases. And she said, well, that's not right. I lived for quite a while in Joliet, Illinois, and I tried a lot of cases there before I came back to Indiana. Well, the Evansville Courier and Press decided to try and find that out. So they assigned a reporter to look at her record, in Illinois. So they called the Illinois Supreme Court, and the Illinois Supreme Court said, well, we don't have any system like that. We really can't tell you how many she tried. We can't tell you which cases she tried, but there are some contractors around, and they work in different counties under contract. And so why don't you call the people in Joliet? And the newspaper called them, and they said, well, the people in Joliet said, we haven't gotten to that yet. We can't tell you. Well, that's not Indiana, by gosh. You could put your finger onto the pad and find out exactly which cases she had litigated. Turned out she litigated quite a number, and she won the election. But the contrast between Illinois and Indiana was I thought was a matter of great pride.
Now, one of the things that we want to know about is that how is the Supreme Court justice currently appointed, elected? How's that process in terms of our current court and how they become judges?
Well, this is a system that the voters adopted 50 years ago in the fall of 1970, originally developed in Missouri, and so it's often called the Missouri Plan, also called the merit system. What happens is if there's an opening on the bench, this is in the appellate courts and in a few of our urban courts. If there's an opening on the bench, you put up a help wanted sign, and people who are interested in the appointment, it's an appointment filled by the governor, just like it always has in midterm, if you will. If somebody retires early or unfortunately dies in office or something, the governor makes the appointment. This is a restraint in effect on that system that involves both the governor and the public directly. So there's a screening committee called the Judicial Nominating Commission, 7 people, lawyers and non-lawyers, and the Chief Justice chairs it. And they interview people and look at their records and call the references, and then they choose 3. They choose the 3 best they think could do this job well, and they send that list of 3 to the governor, who then chooses which one, and that person then takes office. You sit for a while until finally the public's had at least a little time, at least 2 years, to sort of watch you at work and see whether this has turned out all right or not. And so there is what's called a retention vote. It always seemed highly personal. I'd go into because I've done this 3 times. You'd walk into the polling booth, and down there on one of the panels, it would say, shall Randall T. Shepard be retained in office, yes or no? Somehow the other times I ran, there was somebody on the other side that I was being compared to. I could know a little better about this, but so if the public votes yes, then the appellate judges get a 10-year term, and then they have to do it again. So the public still has a way to decide that they don't think this person's been capable or hard enough working or whatever. And of course, we've got some of that coming around this fall.
Well, having said that, Judge, who's up for retention on the Supreme Court this time around?
Well, we have 3. The Chief Justice of Indiana, Loretta Rush, Mark Massa, one of the associate justices, and Derek Moulter, who is the newest of the five, are on the ballot for the Supreme Court. And if they get a yes, two of them have already been voted on once. Loretta Rush and Mark Massa are up for their second vote. They've already, about 10 years ago, they would have gotten a yes vote from the public. And the question now is, do we still believe that was the right thing to do? And my view is absolutely it is the right thing to do. That the three of them have proven to be very capable, very honest about what they do, and we'd be fortunate as Hoosiers to have them continue in this leadership role.
So your position is that the public should vote yes to retain these judges? If so,
Yes,
why?
yes. Hmm?
Why should they vote?
Well,
yes
I think you can look at the careers and the work of all three of them, and you can look at it online. They actually the court system actually posts a retention vote page where you can look at the history of this person, read this person's opinions, watch this person in oral argument. They'll put views of court cases that they've heard, so you can sort of feel what this person is like and how they approach the job. And I think that in all three of these cases, you've got really terrific people. Loretta Rush began her legal career as a litigator in Lafayette, spent the better part of a decade as a trial judge in Lafayette, and now has been 10 years or so on the Supreme Court. She was chosen in terms of national leadership, she was chosen to be the head of the Conference of Chief Justices. So the 50 other Supreme Court justices in the country thought she was a good leader, and I think they were right. And Mark Massa was started out as a reporter, actually, then went to law school and became a law clerk, and then he has spent time working as a deputy prosecutor and worked in the governor's office for a period of time, and has really put his shoulder to the wheel in getting things accomplished at the Supreme Court. Derek Moulter is from Northwest Indiana and is the newest member. He was a litigator in a large law firm in Indianapolis, very well regarded. He got appointed to the Court of Appeals maybe 5 years ago, no more than that, 5 years ago probably. And then there was an opening on the Supreme Court, and he applied, and he got appointed to that. So he's obviously had a careful look at his qualifications, and people who pay attention to this sort of thing have thought he was a good player, and I think they've done the right thing.
Well, the tough question is that how well does the local legal community and the state legal community, do they support retention of these judges? Did it in a high number?
Yeah, absolutely. There are polls taken inviting lawyers, practicing lawyers, to vote to what do you think, lawyer? Is this a person we ought to keep, or should we look for somebody better? And the votes on for the yes votes, the retaining votes among lawyers, are wonderful. They're in the 80% yes. I think Justice Rush, I think it's either 86% or 88%, and the other two were also in the mid 80s. So the people who really watch, and you're talking about lawyers of all kinds, prosecuting attorneys, defense lawyers, plaintiffs lawyers, defense lawyers, are all a part of this, and opportunity to say yes or no, and they think that these are good choices. So we have other retentions. So we have two Court of Appeals judges, and I'd say the same thing about them. They're lively. They're also in Marion County in Indianapolis, as you know. There are some trial judges who are up for retention. But you've asked me about the Supremes, and I would say yes, yes, and yes.
Let me. I see we got some calls. Let me take a quick call real quick before I go to the next question. Caller, you had a question or comment for the Chief Justice Day. Hello.
Yes. Can you hear me?
Yes, sir.
This is Guy calling, and I was just wondering what your take is at this date, before a few days before the presidential election, in terms of particularly the recent report of a young man being arrested in Maricopa County, Arizona, for trying to destroy a mailbox, which supposedly, I guess, he felt that mail-in voting was a problem to his particular candidate.
I can't. I'd have to tell you, I don't know any of the details of that. As a broad matter, I would say burning mailboxes, it's a good thing. It's against the law. We shouldn't be doing it for any reason. Whether he's guilty or not, I don't know. But one of the things I wanted to go back and mention is that this sort of stuff doesn't happen in Indiana. And we ought to be proud of that. I can remember we had a governor's race one time when one candidate started running ads saying that his opponent was vaguely stated his opponent was a crook who took public money. There were enough people around who knew that just wasn't true. They knew the opposite candidate who was being criticized, and they knew that he was just honest as the day is long. And that ad got pulled in 5 days because people in Indiana paid enough attention and they knew enough about. So those kind of things, we're maybe not as we're not as quite as easygoing as we used to be, but I still think we have a better record on that score than an awful lot of places. But I guess I don't know quite enough detail. If it's true, then it's something you shouldn't be doing.
And also callers, they sent me some texts. I had mentioned that you worked on township government, and the caller wanted to know, they had some questions about township government, and they want to know what improvement did you come up with for local government when you were on that committee?
Yeah, well, the first thing to mention is that I was co-chair, and the former Governor Joe Kernan was the other co-chair. So the report itself is sometimes called the Kernan-Shepard report. I once said to the legislature, it's a little it's unusual and unexpected that I might become well known for being at the back end of a hyphen. Because that's the way it was spelled. It was Kernan -Shepard Shepard. But I also said if you were going to be at the back end of the hyphen, how could you do better than have Joe Kernan at the front end? That's a terrific honor and very interesting experience. And I think among other things, that made, I'll give you probably the most public difference. There were, I think, 27 recommendations. This happened during the Daniels years. And he asked us to do this before he was getting ready to run for re-election. He said, we're going to be recruiting candidates. And I keep hearing we need to make some changes in local government structure. And I'd sort of like some expert advice on what those ought to be. But here's for instance, probably the most dramatic one, I would say. Well, we had, for example, there weren't any very effective rules about hiring your relatives to work in public posts. So you could hire not just your boyfriend or girlfriend. You could hire your cousin and start paying them. And we recommended that within a certain range that not be permitted, and that took place. That was adopted by the legislature. Another one was that we have 1,008, I think, townships in Indiana, and all of them have a township trustee, a township board, and they used to have a township justice of the peace. Indiana decided it wanted county courts back in the 70s. The township assessors were chosen, and there weren't any actual qualifications for that. So whether you had any experience in real estate or in appraisal, because that's one of the key things they did, was to assess the value of homes and then on which taxes would be levied. And so you get in a single county, you'd end up with 7, 8, 9 different township assessors. We thought that was probably tough on taxpayers and also tough on business, because you didn't know whether how you were going to get assessed and whether that was going to be a reasonable assessment, a professional one. We recommended that those offices be combined into the county assessor, and the legislature did that. There were a few places where the legislature said, "Well, let's do a local referendum." I think there were about 6 or 7, maybe 8, where it was decided you'd put that on the ballot, and the voters voted to discontinue those offices in all but about, as I say, in all but about 6 or 7 places where they're still, and they tended to be pretty good sized places, which meant probably you were going to end up with relatively professional folks, just because there was a big enough business that you could afford to pay a salary that would attract people to come in and do this.
Okay, we have another caller. Caller, unmute now. Caller, you have a question for the Chief Justice? Hello? You have to unmute. Cox, unmute. Okay, he's currently can't unmute. Oh, while he's trying to unmute, let me go to the next. What is the important lesson from being at the top of the judicial system that you learned in terms of the practice? How is this evolving today? And do we have a shortage of lawyers now in our state?
Good. 2 good questions. Well, one of the things one of the differences between being a practicing lawyer or a trial judge and being an appellate judge is that in those first 2 jobs, day in and day out, you actually come into contact with citizens, clients or litigants show up in the courtroom. And in the appellate courts, that may happen when you have oral argument on a case. But one of the things it's good to remind yourself that these cases are not academic. They involve actual citizens, actual people, and you need to try to remember that. And it's a good thing about being a trial judge is that you actually see the people on whose future you're about to rule on this or that, whether it's divorce or a criminal case. They actually walk into court, even including small claims court. I would try small claims cases. I once tried don't know if it was a small claim. It was a $3,000 or $4,000 case by jury, trial by jury. Now that was back when 3 or 4,000 was, by inflation, it was worth more than that in today's dollars. But it was a very interesting experience. It was a auto collision. I'm sorry if I'm taking up too much time on this. An auto collision, and nobody was injured, but there were a couple $1,000s worth of damage, and there was a disagreement between the parties. They just couldn't settle. So the two lawyers who were big names in our city, really big names, said, let's just try the case. Let's bring in 6 Hoosiers and we'll put our witnesses on the stand. I really didn't feel old enough or qualified. These were preeminent lawyers. But that's one thing about the American system is you're frequently you bring in independent people whom you've never seen and they've never seen you, and they just listen to the proof and move on.
Okay, Chief Justice, the next question from our audience has to do with the cost of attorney. They say that attorneys' fees are too high now for consumer type cases, that if you do cases like, for example, in small claims court, they have high paid lawyers, but you can't get private lawyers to take on these type cases. What can be done by the court to address the spiraling cost of litigation, particularly for these consumer type complaints, if anything?
Yeah. Well, there are a couple of things that the court has done over time that can be deployed. One of those is mediation. A judge who sees a case where there ought to be a possibility of a settlement, but it hadn't happened yet, can require the parties to go have a discussion with a professional mediator, negotiator, somebody independent who's not a part of this lawsuit. And the number of those in our state's been rising continually over the last decade or two, and it can make a difference for citizens who don't have enough money to hire a regular lawyer. There are also, and you would know this, there are also times when a lawyer will say, boy, somebody's walked into my office, they really need help, but they can't afford my regular fee. And the lawyer will accommodate that in one way or another, just because, many lawyers come to this job because they want to be helpful. And so sometimes, as long as you can keep the doors open and the rent paid at the law office, there are plenty of times when judges. Now then, as you mentioned earlier, the other issue on the table at the moment is how many lawyers are there, particularly in rural counties. And I'm glad to say this is so characteristic of our Supreme Court, has launched a project to talk about how do we get lawyers to put their foot down in a small county and earn a living, but make it more available for legal help. They also the Indiana Legal Foundation has now put a legal help booth in every county. So somebody who doesn't have a lawyer can walk in and ask questions on the computer and look for what is this, how to rent unpaid cases in small claims court, how do they work, and what's the law on this or that. So that's classic of this Supreme Court, is that they're always looking for ways to make it easier and easier to get it right, and to help people of all walks of life.
Well, Chief Justice, you've been part of the committee that makes some changes to a bar admission process. Tell us about the process and what happened.
Well, the basic way you get to be a lawyer, traditionally, of course, is that you finish college, you attend law school and graduate, and then you have to pass a bar exam. And one of the things that's changed over time is that, the percentage of people who pass the exam usually has been pretty good, 70%, 80%, and you can try it again if you think you could do better the second time, and then you get your license. One of the things that Indiana has done, and actually did quite some time ago, was to adopt a national test that most other states have adopted, called the Uniform Bar Exam. And one of the great benefits of that is that if you pass that, and it covers a lot of the things that our own Indiana-only exam would have covered. But if you pass that, you can take your score anywhere in the United States. So if you went to law school in Kentucky, but you really like to become a lawyer in Cincinnati, you can hope, if that score meets the Cincinnati standard, you don't have to go through it all again. You hand Ohio your score, and they'll give you a license in Ohio. And Indiana now does that. And that is something that the law schools and the Supreme Court led on. There's now more discussion about what's the value of distance learning, or how should distance learning figure into that at all? But one of the state now is at work, the Supreme Court now at work on how to make it easier for lawyers to be in the rural areas that we discussed earlier, where it's just a question of finding a lawyer at all, because there aren't that many in your county.
Attorney Banks, one of the Superstar panel members, she was president of National Bar, and she also worked for major corporation, Master Tax, cybersecurity. She has some interesting. Attorney Banks, are you still there?
I am, Attorney Lee.
Yeah, go ahead. Do you have any questions for the Chief Justice?
Well, I am looking at one of the questions in the chat box, Justice Shepard. And again, it's such an honor to have you join the show today. And one of our callers has asked whether you will defend the CLEO program against anti-diversity efforts.
Good for your caller. The answer is, you bet I will. Our listeners should know that this is a program created by the Indiana Supreme Court, and the objective was to increase the number of minority lawyers, disadvantaged lawyers, disadvantaged students who didn't have a chance to get the sort of high school or college education that would propel them into the practice of law. And you're right that it was mostly aimed at minority students. We have now had 700 graduates of that program have now gone through to become lawyers, and God bless Indiana. Our legislature has spent. Think about that. Our legislature has spent almost $20 million in helping young disadvantaged students become lawyers, and that helps them, but it helps a lot of other people too. There is, because of the litigation about admittance for Harvard and North Carolina, isn't it? Duke, maybe. There is a ground for concern about whether that disadvantages one group over another in a way that's racial. Is it fair to white kids, white students? Pardon me. And so I think one of the things that's happened is that the programs like CLEO, good old Indiana, imagine that our Indiana, here's the thing, going back to what do you think about Indiana? This program was adopted by our legislature in the House of Representatives. The vote to create CLEO was 91-7. And in the Senate, I think it was 49-0. And so give Indiana credit on some of these days. When I proposed this to the legislature, I said, this is the sort of affirmative action that Jesse Jackson and Richard Nixon would both sign off on. And I still think that. So, but we got to, you're absolutely right. We've got to be careful about how it does. And I think our CLEO committee, on which our colleague here once served, if I'm not, I think I'm right about that, huh?
For a long time.
Yeah, right. And I think I think they're very alert to making sure that this program has a strong basis and can survive litigation. God bless Indiana.
Yeah.
That's absolutely outstanding. I had the opportunity to serve on the National CLEO board and as its secretary, and also had the opportunity. I had been admitted to Valparaiso University Law School and had also applied to the CLEO program and had the opportunity to attend the CLEO Institute at Notre Dame University before I matriculated into my first year of law school. It's an excellent program that introduces students that have been admitted to law school to an overview, if you will, of what the first year law school curriculum is all about.
Well, just to that's a great description of what it tries to make happen. And let's say in passing, may it rest in peace, Valparaiso Law School. I'm so sorry that we lost it. I think it was a grand contributor to legal education and to the making it available to minority lawyers. So we need to honor the people who tried to keep it going.
And for the audience, our current Chief Justice is a big supporter of the CLEO program, Chief Justice Loretta Rush. By the way, Judge, is she the first female Chief Justice in Indiana?
She is. She's only the second woman on the court. And if you look at, but the general trend there has been changing very favorably. You know, the Indiana Court of Appeals is real close to 50-50 now. And when I was a trial judge, I think I was a member of the board of the Judges Association. If you were active in the judiciary, you knew how many women judges there were in Indiana, and the number in the 80s was something like 18 out of several hundred. And now most people couldn't tell you, because there are a wonderful assembly of women in the judiciary and in law schools. It's pretty much, in fact, I think Ms. Banks might know the answer to this. I think at the moment there are actually more women in law schools in America than there are men.
That is true. That is absolutely true, Your Honor.
Well, it's a phenomenal type progress that we made. But here's the deal. I got to tell you, Chief Justice, I'm a big supporter of the Supreme Court for different reasons. I'm a plaintiff lawyer and I do a lot of trial work. And I think that they've done a good job in terms of making the playing field fair for both sides. And that's what we're seeking. You know, we're seeking accountability, and the courts have been pretty consistent. And so as a lawyer, I need to be able to know the outcome of a trial and then say, okay, if it goes up on appeal, what are the judges going to say? And so because you have these printed opinion, you kind of know how to prepare your case. And that's why it's important. So you don't like these changes all the time. You like to, a lot of people don't understand that. You need to know how a judge rules on evidence rules and things like that. And I think that's important. And that's why I'm supporting them. I'm a big supporter of them. And we had an event, just share a personal story the other night. I was lucky to get an award by the Bar Association, but one of the first person I was talked to was the Chief Justice. She showed up, and I got a chance to talk to her, and she was very concerned. And the other thing that was unusual about that is that I did not know most of the lawyers. When I started practicing law, Attorney Banks, and she could verify this, I know all the Black lawyers in the areas, like all 40. Now there's 100. And, it was just shocking to me in terms of progress. I was glad to see that.
Well, I'm glad to be on the same team as you are in terms of retaining Loretta Rush and her comrades. I think Indiana is being well served, and we're fortunate to have them.
Attorney Banks, any final comments?
Well, I would just say that judges matter. And I want to thank Justice Shepard for being with us today. I'm seeing in the chat box, one of our callers is saying great information. And so thank you so much, Justice Shepard, for being here. I want to also say to our listening audience, make sure that you have your voting plan. Make a voting plan if you don't have one. And then ensure that your community of 10 family members and family have their voting plan. And you also have the opportunity to view your ballot before you go to vote. And so make sure that you read your ballot all the way to the bottom, and make sure that you know your judges, because judges do matter. And those are my comments today. And thank you again, Justice Shepard, for being with us. We really appreciate your leadership.
One final comment. I voted early, and I was happy to cast my retention vote. But, you have to look at the ballot. It's a little bit different. They have the people running for county and state, but the judges, you just vote yes. So don't forget, just check the box yes for retention. It's pretty simple. And thank you, Chief Justice, for joining our show. You back on the show back in the 90s, I remember last time. So thank you. And thank you for your service, and thank you for your leadership in these important issues. And so, listener orders, thank you for listening today. And next week, come join us again as we deal with another legal subject. Thank you, everyone, and have a blessed day.
Glad to be in.